A federal judge has rejected the Trump administration's Association Health Plan rule. Now, we're going back to 2017 to set up the timeline for this Association Health Plan rule. You might remember the Trump administration issued an executive order saying, try to find a way to make association health plans and short-term insurance plans work. And then it came to the agencies to try to find a way to implement those in the form of rules. Well, the Department of Labor jumped at the chance to create an association health plan rule that became a final rule. It treats association health plans like large employer health plans, which means they're subject to ERISA rules, and it therefore took them out of a lot of the consumer protections and other mandates of the Affordable Care Act. So small businesses were allowed to band together to form associations, and the definition of small businesses banding together was quite loose. It could be small business owners, their employees, sole proprietors, or other self-employed people banding together, creating associations, and therefore being treated more like large group employee plans as opposed to the individual plans or the small group plans that you might see under the Affordable Care Act regulations. Now, the rule exempted association health plans from ACA requirements like essential health benefit protections, medical loss ratio, and premium rating restrictions, and it also didn't pay any attention to underwriting rules about charging people more based on age, gender, or geography. So there were a lot of individuals that were not too happy with this final rule. It had a staggered implementation date. So for groups that already were in some sort of an association, there was an applicability date. There was a timeline that was coming up quite quickly. If you wanted to form a brand new association health plan, you wouldn't be able to do that until after April 1st. So when this came to a head, there was a legal challenge that started back in July of 2018, and we could presume that a decision had to come before that April 1st date, and it did. So let's walk ourselves through this legal challenge. In July of 2018, 11 states in the District of Columbia filed a complaint in the U.S. District Court for the District of Columbia saying this rule is unlawful. It's inconsistent with the text, the structure, and the history of the Affordable Care Act, and it seems to go outside of what ERISA rules even allow. So it was created, they said, to just simply avoid the stringent requirements of the Affordable Care Act, which we knew from the executive order that came down saying find a way to create what a lot of analysts call junk insurance plans, association health plans, and short-term plans. Create these plans to get around the requirements of the Affordable Care Act. So it's no surprise that that was the legal challenge, saying these are simply just trying to get around the restrictions, and in so doing, they're violating the text and the intent of Congress when it drafted the Affordable Care Act and parts of ERISA. And the district judge, John Bates, agreed. His ruling came before April 1st. It came March 28th. He said it goes beyond the authority of ERISA, which regulates large group plans, and it was designed, this rule was designed to circumvent the Affordable Care Act, just as those states argued. So it does so by ignoring the language and purpose of ERISA and the ACA, and it essentially struck down the definition of employer and employee, the foundation of these rules. Now, the legal challenge went on to go, and this is what the judge said, that this is counter to congressional intent. He said it was unreasonable to bring working owners together without employees within ERISA's scope. He said ERISA was never designed to have individuals be treated as large group employers. He called the Department of Labor's logic of forming associations the way that they did to make this rule work a magic trick, which was pretty harsh language coming from this judge, but it wasn't as harsh as the way he referred to the results as absurd. In fact, this judge used the word absurd quite regularly in his decision. He vacated the rule's bona fide association and working owner provisions, which was a big deal, and now it's up to the Department of Labor to decide if they're going to tweak the language of the rule and rewrite it, or if they're going to just appeal this judge's decision and stick to the courts for their remedy. Now, in the meantime, some association health plans had already been forming and following some of the rule. So they presumably, because the judge vacated this rule, they presumably now need to either follow the Affordable Care Act and state regulations or disband. So like we said, the Department of Labor can appeal this, or they can simply go back and revise the rule. Historically, association health plans have had a spotty track record. The Department of Labor themselves identified association health plans in the past, before the Affordable Care Act was even signed into law in 2010, as having a history of fraud and abuse because they were loosely regulated and undercapitalized. Now, some people unable to pay benefits were depriving members of meaningful coverage. Others had multiple complaints just about the misunderstanding of what was actually covered and what rules were regulating them at the time. So federal legislation was actually drafted in the 80s to place association health plans under the purview of the states. Well, this federal rule that was being challenged, threw it back to the feds to regulate. And now we can see why this long history of discontent with association health plans has been happening, especially in light of the facts of the consumer protections and the new regulations of the Affordable Care Act. What's at stake? Well, it really is just a conversation of what your risk pool looks like. If you have association health plans that do not have to follow the Affordable Care Act, you can presume that some plans might be able to charge a little bit less for those plans because they don't have to offer as much coverage. So it's one of those provisions that has been called sabotage of the Affordable Care Act because it chips away at the risk pool. So we need to see what's happening. Is this destabilizing the individual market? Is it chipping away at the Affordable Care Act? Or is this just an attempt to get more people coverage? And the debate doesn't seem to be too strong that it's just trying to get more people coverage. It does seem like it's just trying to infer less regulation. You can read the opinion coming out of that District Judge Bates. You can read the final rule that is the one that is being challenged. And then you can send us your questions or comments on this. What do you think the Department of Labor is going to do? Are they going to tweak the rule, or are they going to stick to the route of appeal through the courts? If you have questions, you can send us an email, and you can find us at healthwatchwisconsin.org.